Next up is Rebecca. This is another topic that has been requested by multiple people, and Rebecca, cannot find just right off your bio, so I'm going to let you introduce yourself.
That's okay. I'll just tell you, my name is Rebecca Meyer. I'm a state contract analyst. I've been with the state for over 2 years and practicing attorney for over 25 years. So I have a lot of experience in sort of this legal world. It's great to be here with all of you. The last time I taught a training, I was the first speaker of the day. Everyone was bright-eyed and eager to start the training day. As you probably realize, I'm the last speaker of the day today, and you're all probably looking at your clock and your watches and getting a little hungry, looking forward to lunchtime, and you're wondering, will this speaker take the whole time, or will we get out of here a few minutes early? I guess you'll just have to wait and see, but I will tell you it will depend on how fast I talk and how many questions you ask. Today, we're going to be talking about the exciting topic of GRAMA. Let me give you a little overview of my training today. I'm going to talk about the legal foundations for GRAMA, about record classifications. We'll do a little bit of procurement specifics, a little bit about management and retention of records. We're going to begin with the legal foundations of GRAMA. So what is GRAMA and where is it found in the law? Let us start by understanding what GRAMA stands for. GRAMA stands for the Government Records Access and Management Act. GRAMA was passed into law in 1991 and went into effect in 1992. GRAMA is found in Title 63, Chapter 2, and it's Utah's comprehensive records law. The provisions of GRAMA govern the process by which the public may access government records. GRAMA provides a classification structure which identifies records that may be made available to the public and the records for which access should be restricted. GRAMA also provides a process by which the public may request records, referred to as GRAMA request. So GRAMA is both nuanced and simple. GRAMA provides a process for making and responding to records requests and establishes a classification framework for responders to work with. GRAMA promotes the public's access to public records while providing guidelines for both disclosure and restrictions on access to government records. GRAMA recognizes and attempts to provide a balance for two very important constitutional rights: the public's right to access the information concerning the public's business and the right of privacy in relation to personal data gathered by governmental entities. So GRAMA is divided into 9 parts. We will focus today mostly on Utah Code 63G2 1 through 3. So part 1 is the general provisions. This part provides definitions and the requirement for the record officer certification. We'll talk about that in a second. Then we will also talk about how important it is to note that you must be trained to be a GRAMA records officer. Part 2 is the access to records. This part details the process for making record requests and identifies who can have access to the records. Part 3 is going to be the classification we will go into. It identifies and lays out the structure that maps out which records are available to the public and which should be restricted from public access. So now let's talk about the roles of the ARO and the CAO. First, what is an ARO? An ARO is an appointed record officer. An ARO's duties include being the designated point person for archives. Being an ARO requires annual certification. An ARO is the person who responds and answers GRAMA requests when they come into an entity. Now, what is a CAO? The CAO is the Chief Administrative Officer. The CAO's duties are also defined by statute. The CAO is responsible for policy and procedures, functions and proper documentation of the organization, and for handling GRAMA appeals. So now, one of the most important things that we're going to talk about is records classification. Under GRAMA, there's a duty to classify records. With that duty, the record holder is required to evaluate and designate the record. It's extremely important to note that a governmental entity may classify a particular record, record series, or information within a record at any time, but is not required to classify a particular record, record series, or information until access to the record is requested. So that means you don't have to classify every record that your entity has or could potentially have. It does mean that when a GRAMA request comes in, the entity must make a classification at that time and determine if the record is public or is the record controlled, private, or protected. There are 4 classifications in GRAMA: public, private, controlled, and protected. A person has a right to inspect a public record. However, access is limited to controlled, private, and protected. It's important for us to note that all records are public unless they are expressly provided by statute. Okay, so what is a public record or public information? A public record means a record that is not private, controlled, protected, or exempt. Seems like we use these same words over and over to define themselves. Let me give you some examples of what public records are. So public records are things like awarded contracts, final aggregate evaluation scores, solicitation responses after the contract's been awarded. And GRAMA has 2 tiers of what we call public records. The first is public except, meaning the record must be disclosed but may contain confidential information that's redacted. The second tier of public records is one that is normally public unless otherwise stated. So let's talk about private information. Private records contain data on individuals that is private, as provided in Section 63G2302. The private classification is usually applied to records about an individual. These records are always private. For example, employment records, records concerning an individual's eligibility for unemployment insurance benefits, social services, welfare benefits, or the determination of benefit levels. These are always considered private information. So now let's talk a little bit about controlled records. So controlled records contain data on individuals that is controlled as provided in Section 63G2304. A record is controlled if the record contains medical, psychiatric, or psychological data about an individual. If the governmental entity reasonably believes that releasing information in the record to the subject of the record would be detrimental to the subject's mental health or the safety of any individual, or releasing that information would constitute a violation of normal professional practice and medical ethics, it's considered controlled and would not be released. Now let's talk about protected records. Protected records are records that are classified protected as provided by 63G2305. The protected classification is usually applied to records about a government entity or organization. Now, hear what I just said. Protected classification is usually applied to records about a government entity or organization. The records are usually classified as protected because there is a strong public policy or interest in that non-disclosure. The list of protected records grows every single legislative session. Some of the items that are considered protected records are trade secrets, attorney-client privileges, jeopardizing life or safety of individuals, imminent or impending litigation. For procurement professionals, it's important to read and understand 63G2305, 6, and 7. So I'm going to go through that. So we're not being heavily code specific, but GRAMA does require a lot of the discussion of specific codes. Section 6 says records, the disclosure of which would impair the governmental procurement proceedings or give an unfair advantage to any person proposing to enter into a contract or agreement with a governmental entity. And then it goes on to say that this subsection 6 does not restrict the right of a person to have access to after the contract or grant has been awarded and signed by all parties. A bid, a proposal, an application, or other information submitted to or by a governmental entity in response to an invitation for bids, a request for proposal, a request for quotes, a grant, or other similar document, or an unsolicited proposal as defined in Section 63G 6A 712. So let's talk about a recent example of classifying documents as protected. And this one came from Mr. Blake Porter. Even when records are properly classified as protected under this code section, It does not mean that an individual that requests access to the records will not get them. Let me explain. The Division of Purchasing ran a large multiple award RFP recently. There was a GRAMA request, actually more than one that came in for records regarding the RFP. The contracts were still being negotiated and had not been fully executed. The RFP records were correctly classified as protected, and the GRAMA requests were denied. The requesters appealed the decision, and the court determined that the records would have to be disclosed. The court used the weighing provisions in 63G24047 to require disclosure of the protected documents. So in 63G24047, it states that the court may, upon consideration and weighing of the various interests and public policies pertinent to the classification and disclosure or non-disclosure, order the disclosure of information properly classified as controlled or protected if the interest favoring access is greater than or equal to the interest in favoring restriction of access. So even though it was correctly denied under the GRAMA rules and it was a protected document, the court still released those documents. So that's a great example of how we can do everything exactly as the code says, and the courts can still come in and say, well, under the weighing provisions, we've decided you need to release those documents. Anything else, Blake, you want to add to that one, or is that good?
I better not make any other comments out of my bitterness and pain, so I'm good.
Okay. All right. So let's go on. So let's talk about procurement-specific GRAMA. What to do when you receive a GRAMA request. Step one, figure out who the appointed records officer is for your entity, or who handles these GRAMA requests when they come in. When you receive a GRAMA request, make sure you document when you receive it. The law requires that a governmental entity review the requested records and respond as soon as reasonably possible, but no later than 10 business days after receiving the request. So, step two, is the GRAMA request in writing? The person making the request shall make the request in writing. Written requests may be submitted in any format as long as it's written. It can't be a phone call asking for them. It has to be written. Step three, is it from a person as defined in GRAMA and not a governmental entity? And does it include a name and contact info? So it's important to know that a person under GRAMA can be an individual, a nonprofit, a partnership, or other type of business organization. A person making the request shall provide their name, address, daytime phone number, email address, and description of the requested record. Step four, was it received by the right governmental entity? A person making a request shall submit that request to the governmental entity that prepares, owns, or retains the record. If the governmental entity does not maintain the requested records, the ARO should notify the requester that it does not maintain the record requested and provide, if known, the name, address of the governmental entity that does maintain the record. Step five, is the description of the record reasonably specific? So what are they asking for? Is the request, it has to be specific enough to enable a government entity to begin to process the request, and if a clarification is required, to ask the relevant questions to understand the scope of the request. It can't be just general, I want, and just leave it open so you have no idea what documents they're really asking for or what you need to go and retrieve. So, responding to a GRAMA request. Now that you're sure that the record is your responsibility and you know what they want, you need to know how to respond to this GRAMA request. So, responding to GRAMA request. First, identify the responsive records. Next, this is an important one, you can calculate the cost. A governmental entity may charge a reasonable fee to cover the governmental entity's actual cost of providing the record. The fee must be approved by the entity's executive officer. And there's some other things there. So if you're going to charge a fee for this, you've got to make sure you follow the code and rule exactly what you can charge. And it has to be approved. Okay, so next one, part three. You have to classify the responsive records. Ask yourself, is it a record? A record means documentary material, regardless of physical form or characteristics, that is prepared, owned, received, or retained by a governmental entity, and where all of the information in the original is reproducible. So a record does not mean a personal note or communication, a temporary draft or similar material, proprietary software, commercial mail or publications, or other items listed under Utah Code 63G210325B. And then finally, plan your response. And again, you as the person receiving it may not be the one doing it. It may be your records officer, and the records officer has to figure out what we're going to do and how we're going to respond to this and what we're going to provide. So, big question people have been asking, digital versus hard copies. GRAMA does not prioritize paper over digital. Retention is based on the content of the record. So the record copy, you designate one official copy. It can be digital or it can be paper. All others are considered duplicates. Then we have a scanning policy under GRAMA. The originals can be destroyed after scanning if the digital file is unalterable and quality checked. It can't be scanned in and not be readable. It can't be scanned in and missing half a document. It has to be quality checked and make sure that it's all there and everyone can read what the original document was, if that's going to become the original. Searchability. Digital records facilitate faster responses to high volume GRAMA requests. They're great, but you've got to make sure if you have them in a digital form that that becomes your original form and the papers are now duplicates. Finding retention schedules. I have people ask me all the time, how long do I have to keep this document? How long do I have to keep this? And I will say, it depends. Always check your agency or entity specific schedules. A lot of you have very specific requirements that you need to keep, but there is the Division of Archives and Records website. Down here on their website, it specifically has record series and retention schedules, and you can go in there and you can look at it and you can determine what you're supposed to keep, how long you're supposed to keep it, and you can always keep it more time. You can't keep it less time. Okay. And that is GRAMA in a nutshell, really fast. Any questions? Go ahead, Anthony.
When you look at the private, there's a couple circular things that says these kind of things are typically normal, but there's other sections that could apply. And when it comes to like private or public or controlled records, I think one thing that comes up a lot in procurement, I'm just curious what maybe the state's approach on this is, or we have a different term where a company in a bid process can submit a business confidentiality claim. And that doesn't seem to be represented in code as and maybe I'm missing the circular argument where, is that a protected record? A vendor can say, you know, I'm a big vendor. If you release my pricing, that's a business advantage that somebody else would get. So what happens? I'm sure you guys get this. When you're doing a bid and somebody goes, I would like a copy of the current incumbent's contract and pricing. What is the typical response to that? And how does that play in with is pricing a protected record, or is it only a protected record if certain documentation or claims by the vendor are made, if that makes sense?
Yeah, I have some thoughts on that, if it's cool, Rebecca.
Yeah, go ahead.
So the business confidentiality claim portion is part of GRAMA. So when they submit that form and they're claiming that business confidentiality claim, there's only kind of relatively specific things that they can claim as business confidentiality. That's trade secrets, by the way, and commercial financial information that, if disclosed, would be unfair to them or cause a business injury or something. But yeah, so, they could say like, well, my pricing, I've maybe heard that argument before, that my actual just pricing, not how I derive my pricing, not my cost, how I get, my margins of how much money I'm going to make with that pricing, that kind of stuff would be protected. But the actual pricing itself, I just don't really think there's good arguments as to why the pricing itself could be a trade secret. Ultimately, especially when you're dealing with the government, like where we spend the money, how much we spend on things, like that's going to be, there's going to be additional records as, somewhere along the lines that's going to be public information, somewhere along the lines of what we paid for something. So I think the actual pricing information is not going to stand up to snuff under the statute of what a trade secret is or commercial financial information. But other things could be. So for example, their margin, their costs, some of those things might potentially, they're not necessarily going to be required to disclose what their cost is, right? So that's a little bit different. But I don't know if that helped answer your question, but I just don't think those arguments are very good in terms of just their pricing being confidential.
Yeah, there's some history of some ones that I know of that it might delve into the other things you talked about. Long years ago, before my time, even Pepsi and Coke, when you have pouring rights contracts, there's only two big players in the market. And as soon as you release the pricing model of one, right? So I get that. I get what you're saying. I think mine might have some nuance to it. But I guess in the other part of my question, does the state have a stance or a normal protocol for when you post a bid and competing vendors goes, I would like a copy of the current contract and pricing? Do you answer them with it, or do you say during an open solicitation we don't divulge such information?
Our normal response in that is you can request a GRAMA request for that, and here's the link to make a GRAMA request.
And we might
if the agency wanted to, they could just post it if they think it's helpful. It is ultimately, unless there's portions of the existing contract that have been redacted or something because of business confidentiality claim. In general, that contract is a public record. So it could go out. So if the agency wanted to, they're like, oh yeah, just get it out there. We want everyone to see everything. We would do that for them if that's what they wanted. But kind of our general high level response would be like, you can make a GRAMA request and here's the link to go make a GRAMA request.
Perfect. Thank you.
Hey, Rebecca, could you check out the chat while you're...
I certainly will. So Jennifer asked in the chat, how much time do you have to get the records they request? 10 days, unless it's extremely voluminous or there's a problem with getting them, and then there's some extension time we can have in there. But it's 10 business days from the time the request comes in. Yep. Can someone GRAMA individual scores for an RFP? Somebody can GRAMA anything. So they can ask for anything. Whether it'll get approved or not is another question. No, usually the individual scores are not given out.
Yeah, usually. So I just got done saying the grief is too near and I wasn't going to talk about it, but that is actually one of the documents that for the first time, to my knowledge, we released per court order. We didn't show the name associated to the individual scores, but we did show the individual draft scores of the evaluators per a GRAMA request, even though in R33 it specifically says not to do that.
Just from our position, we usually will deny those. We always will deny those requests that come in unless they appeal it, take it to a court, and a court orders us to release it.
Yeah, and they are protected, and they are in R33. If you follow R33 specifically, not supposed to go out even if there is a GRAMA request, that specific document. But when a court tells you to do things, you do things happily. So,
any other questions that I might have missed? I think we hit everything. All right. If there's nothing else, then I am done.
So April, what's the rule number R33 you mean for GRAMA? It's not in that rule. It's governed by another part of the code.
Yeah, GRAMA is its own statute, but the rule I was referencing about individual scores, I can pull up that rule if you'd like.
Thank you.
I think
that is what she's wanting, was the one you were just referencing.
Yeah, so it is R33, I'll type it, R33 107-802. It basically says, and there's a couple sections there, basically says, here's the things that you should release if there's a GRAMA request after the contracts are signed. And then section 2 is like, even after the contracts are signed, we feel like you should not disclose these other things. And that includes the individual scores and the notes of the evaluators.
Blake, are you seeing that last chat? Did you want to respond to it, April's?
Oh, grants can, yep, you do your thing. I don't know much about requests for grant applications. So, yeah, I mean, if you feel like, yeah, as long as it's anonymous, I feel like if that's what you feel like you can share, like cool. I think for us, the reason why we don't want to share the draft score, I guess, would be you are allowed in an RFP process to change your scores after deliberating with the other committee members. That's outlined in R33 as well. So, and I think that just kind of in general, like it may or may not really be relevant, and someone who's not familiar with an RFP process might think that means something that it doesn't. And I also think the more you share of an individual's participation in a RFP, it's going to have a chilling effect on people wanting to serve on evaluation committees, because the more they share of like their individual scores, their drafts, their notes. That's why, of course, we don't include the names with the scores, right? Is because we want people to go after committee members or people to be discouraged from participating in an evaluation committee.
I find that really interesting. With our grant process, we do generally model our requests for grant applications generally on procurement processes, but of course, grants are a little different. However, we've actually found that applicants will find that useful feedback for annual grants. They actually use that. So when we open up grants, we'll often have people send requests through GRAMA for their scores for the previous solicitation cycle, so they can look at what questions they did badly on, right?
Yeah.
And where they can improve. And so I find that really interesting that we actually find that it doesn't chill. We're really transparent with our readers, who are all identified by number. We actually never, in official documentation, the name is never there.
And you're just sharing
yeah.
their final individual scores.
Final scores and comments for
Yeah.
each question.
So yeah, final scores I would maybe not be as opposed to going out, just from a I was mostly thinking of the initial draft scores in an RFP.
Yeah,
process.
no, those are work product. Yeah. Those are protected. But yeah, well, that's really interesting.
You would have thought. Yep.
No, thanks. Sorry. I just wanted to chip in because we actually have found people say this is really helpful for us, and it helps them improve and write better grant applications. So yeah.
Yeah, but my guess is you don't have a protest process where they can then use the information against you. So that's why.
Is there a protest process in a grant application?
We have a 7-day protest period after the intent for conditional award is sent out. But generally the GRAMA scores come in immediately before or as we open the new year. So they're looking actually at last year. We almost never have requests for the current procurement. It's almost always for the prior solicitation.
Yeah, that limits you're helping vendors and not. Like in the procurement world, the biggest one I face, like I alluded to, is we're in an open, transparent solicitation, and somebody wants to go, tell me what you're currently paying so I can undercut it a penny, or it's
a different world. Yeah.
It's a different like dilemma to be in. And how do you embrace fair and also GRAMA? It sometimes has divergent, head on, they butt heads.
Well, and also you're looking at multi-awards often versus single awards. It is a different world. But yeah, I just, since our stuff is modeled on procurement code, I wanted to look at that rule and just see how it was worded. Anyway, sorry.
Yeah, there's the rule reference. You can go take a look, and yeah, no worries.
So I'm going to close this out. Thanks so much for coming. We appreciate it. Thanks to all our presenters for presenting.